Good afternoon, everyone, and welcome to today's webinar. This webinar is being hosted by Uubo and Belo-Osagie, and the subject that we're going to be talking about today is embracing change. Cama, the Companies and Allied Matters Act 2020, and the new face of company law in Nigeria. This piece of legislation is a hugely consequential one. And it's one that the panelists, ourselves, and literally everyone who is on this webinar is going to be grappling with and coming to terms with for years to come, in much the same way that that we did when the Companies and Allied Matters Act was first passed. It's a big and complex piece of legislation. The 1968 Companies Act had 398 sections. The 1990 Companies and Allied Matters Act had 696 sections. Cama 2020 has 870 sections, and that does not include the schedules. So it's big and it's complex, and we're not going to understand it in one day, but let's start today. Let's start the effort today. And we have a great panel. I'll be telling you a little bit more about the panelists as we go along. But this is a panel that comprises 3 partners in the firm, namely Ozofu Ogemudia. Ozofu, you want to? So comprises Ozofu Ogemudia, who you should be able to see to the right of your screen, Christine Shijuade, and Onyinye Okafor. The 3 of them are partners, 3 ladies are partners in the firm. The 4th panelist is Oyinda Ehiwere, and I'll tell you a little bit about Oyinda later. Oyinda is my go-to guy. And Oyinda is the Chief Executive Officer of Allsec Nominees Limited, which is the company secretarial arm of our firm. But I'll tell you a little bit more about the panelists in a bit. But before I do so, a few housekeeping matters. The first is that only panelists and the moderator will be able to use the mics. So in order to provide feedback, etc., participants' mics are going to be muted throughout the presentation. Please start the questions now if you have any, and keep them coming. And please submit the questions using the Q&A tab on the Zoom app. And I think you click the send to all panelists button. And the plan is to answer the questions at the end. Just in case you miss anything, or you're having such a good time that you want to watch it again, and there's always an off chance that that will happen, the webinar is going to be recorded and will be available on YouTube. And finally, if you have technical problems, let us know. Send a note through using the Q&A tab on the Zoom app, and our tech guys will see what they can do to sort it out. So before we start, let me introduce myself. My name is Dan Agbo. I'm the senior partner of Uubo and Belo-Osagie, your host for today. And I'd like to tell you a little bit about the law firm that I am really proud to lead. Uubo and Belo-Osagie seems like forever, but we were founded in 1983 by a gentleman who I hope is on this call, Senator Udoma, the gentleman we're very proud of, but Senator Uubo Udoma founded the firm in 1983. And in 1985, he was joined by Dr. Maima Belo-Osagie when the firm formally became a partnership. I need you to focus on those early numbers for a second, because almost from the foundation of the firm, 37 years ago, and 2 years in, this firm had a 50-50 gender split, gender balance. We were a well gender balanced firm, right? Almost from the beginning. Today, the firm has 15 partners, 8 female and 7 male, and a total of 81 lawyers. And taking the entire lawyer body into consideration, we're still, I would say, almost perfectly gender balanced at both partnership level and at the at every level of the professional staff. Now, the firm practices across a number of areas, but the team that's anchoring today's webinar are from our corporate, M&A, banking, and company secretarial practice teams. We are particularly fortunate to have with us today Ozofu Ogemudia as a panelist. And Ozofu is going to tell you a little bit more about this piece of legislation and how it came to be. But Ozofu was the chairman of the technical committee that was set up by the then president of the Nigerian Senate, essentially to advise the Senate on a draft of the new Companies Act. And Ozofu was supported in that endeavor by Christine Shijuade, who headed the drafting subcommittee, and received input into certain bits of it, and I'll talk about that in a second, from Onye Okafor. So it's great to have the three of them on the call. Ozofu is first up to talk about the things that she thinks are I think, just in terms of, there's lots that's important in the statute. And the approach we decided to adopt today was essentially to have each speaker, starting from the top, focus on what they thought was most important or most consequential for users of the statute. So first up is Ozofu. Ozofu is a corporate partner in Udodoma and Belo-Osagie, specializes in mergers and acquisitions. Has been with the firm for 16 years, so is almost a lifer. Ozofu, please.
Okay, thank you very much, Mr. Agbo. Good afternoon to everyone, and thank you for joining us, sharing your afternoon with us. I'm going to get right to, okay. Just a cue to our IT team to allow me share my screen so I can start. While I'm waiting for that to be enabled, in this, maybe I just start with a few words. In this webinar, what we want to do is to try and inform you about the changes in the Cama 2020 that will have an impact on the way in which you operate your business day to day. Now, some of these changes are big and others are small, but I think that they are all quite impactful. Most of you would have seen newsletters and updates from law firms like ours, 20 things you need to know about Cama and other nice and fancy titles. So most of you have already heard about, the big changes: single member companies, single director companies, abolition of authorized share capital, and changes to various other provisions, and inclusion of company rescue provisions, for instance. The Cama 2020, as Mr. Agbo has already said, is a huge act, and there are amendments all over. And even for those of us that were fortunate to have seen earlier drafts of this act, we're still reading it, we're still getting to understand it. So it's a learning process for all of us. And what we aim to do with this webinar is to get you to join us in this journey of learning about the Cama 2020 and how we're going to operate our businesses under this framework. So with that, I hope I can now get down to the business of the day. Let me see if I can now share my screen. Okay. Okay, so I hope everybody can see my screen. I'm going to, so the first topic I'm going to talk about is share capital and the changes that have been made in relation to share capital. Can everyone see my share capital slide, PowerPoint slide?
Yes, we can see you. We can see it.
Okay. So under the 1990 Cama, we had authorized share capital, issued share capital, paid up share capital, and I think we're all familiar with and comfortable with those concepts. So what has changed? In the Cama 2020, we now have issued and paid up capital. There's no reference in that act to authorized share capital. And why is that? So authorized share capital as a concept has been taken out of our company law. The reason behind this was it was felt that it didn't really, authorized share capital doesn't necessarily tell you anything about the extent to which a company is capitalized. There were companies that had authorized share capital, they were only required to issue a quarter of it, and none of it really had to be paid up. So the authorized share capital was a number, but it wasn't necessarily reflective of value. There was also the issue of front loading of costs. When you create your share capital, you had to pay stamp duty and CAC filing fees on day one, even if you weren't ready to issue it all. And so that was one of the initiatives that was to support small businesses so that they can pay the stamp duty and the CAC filing fees as they go along and whenever they are ready to actually issue those shares. So that at any time, a company will only have paid stamp duty and filing fees on share capital that is actually issued. So how does it work? Under the Cama 2020, the act of authorizing the issuance of your shares is what creates your share capital. It's what creates your issued share capital. So where, for instance, if this is a company that has ₦1 million in share capital and wants to increase it to 2 million, what that company does is that in a general meeting, they pass a resolution saying that the company is authorized to create 1 million additional shares and to issue them to Mr. X. That is it. And then with that resolution, you go with your CAC forms, you pay stamp duty on the new share capital and you file it. And by those acts, your share capital has been increased, your issue, but your share capital at any time is only reflective of what is issued. In addition to that, 25% of your share capital must be paid off. So what are the implications of this? For companies whose share capital is currently below the minimum issued. So under the Cama 2020, the minimum issued share capital for private companies is 100,000 naira. And for public companies is 2 million naira. Now you recall that under the Cama 1990, private companies were supposed to have a minimum authorized of 10,000 naira. So they're actually private companies today whose authorized share capital is 10,000 naira. For such companies, they have 6 months to increase their share capital to the minimum level specified by the Act. So a private company that currently has its share capital at 10,000 naira has to increase it to 100,000 naira within 6 months by issuing 90,000 naira more in shares to shareholders, or to any new shareholders, existing shareholders, up to the company. But they have to sort this out within 6 months. For public companies, the minimum is 2 million. I assume a lot of public companies will already be at or above that level. So what are the implications for companies that currently have unissued shares in their authorized capital? So there are companies that have created authorized share capital, issued some of their shares, but not everything. So they have some unissued shares. The Cama 2020 does not address this. But so what I'm about to say is my opinion and what I believe should happen. I expect that the CAC will, in the regulations that it will have to issue pursuant to this act, confirm what these companies should do. What I think is the reasonable thing to do is that these companies will be allowed to issue their unissued shares up to the level they've paid their stamp duty and CAC filing fees. And then going forward, for any additional shares they issue, they will pay CAC fees and stamp duties at that point. So whether there will be a time frame within which you should issue the shares that you had previously created as authorized and have not yet issued is unclear. But certainly the government should recognize that CAC filing fees and stamp duties have already been paid on those shares and allow the companies to utilize those shares before they then start creating additional capital in line with the Cama 2020. What's the process for increasing your share capital? As I said, the company is required to pass a resolution in general meeting approving the issuance of the creation and issuance of new shares to certain individuals, and then file a return at the CAC within 15 days. Now, there's a provision in Section 127 of the Cama 2020 for companies that require the consent of a regulator before they can file a notification at the CAC. So, for instance, for public companies, when they create new shares, they need to register their shares with the Securities and Exchange Commission before they can actually issue those shares. The process in Section 127 is that where a company is in a situation where it has passed a resolution to increase its issued shares, but needs to get a regulator's approval, what that company does is within 15 days notify the CAC of the fact that it has passed that resolution and of the fact that it has to obtain the consent of a specific regulator. And then a director of the company will file an affidavit to that effect. And so the timeline within which you're supposed to file at CAC, once you submit that notification to CAC, timeline is automatically extended to a period that is 10 days after you get the regulatory approval you're waiting for. Now, if the regulatory approval is not obtained within 48 days, you file another notification to update the CAC, telling them you are still waiting for that regulatory approval, it hasn't yet come. So every period of 48 days that elapses, a notification will be filed to the CAC informing them that you're still waiting for approval, it hasn't yet come, accompanied by an affidavit by a director of the company attesting to those facts. And so the 48-day period will keep rolling over till you get your approval. However, this cannot go on forever. So if the relevant approval is not obtained within 9 months, the share capital increase will lapse, to become null and void, and you have to start the process again. So 9 months to get any regulatory approvals you need, your resolution will remain valid, and you can file your notification at the CAC and not be regarded as being late. In reading through the Cama 2020 and just discussing this with colleagues within the industry, an issue was flagged in relation to Section 127 and Section 149 in relation to the process for increasing share capital. So what Section 127 says is that share capital is to be increased in general meeting but not otherwise. That is not new. It was in the Cama 1990. But the Cama 1990 also allowed companies to delegate the power to issue shares to the board. Section 149 of the Cama 2020 says only private companies can delegate the power to allot shares to their board. And so the question that arises from this is what happens where a public company, for instance, wants to carry out a rights issue, an IPO. And so the shareholders would normally approve the transaction and approve the share capital increase or shares to be allotted, but leave it to the directors to allot shares based on the subscription to the offer. Because on the day when the shareholders are passing the resolution, they don't know whether the offer will be subscribed, whether it will be oversubscribed and the company will be able to accommodate the excess. They don't know who will subscribe for the shares. So they can't actually issue shares to named entities or individuals. So what do they do? Again, this is an issue that I think the CAC will have to address in regulation because it's not clearly provided for in the Act. What I believe should happen is that the terms of the resolution at the general meeting have to be worded as broadly and creatively as possible to ensure that shareholders approve the increase in the issued share capital specify the maximum level at which the share capital can be increased to, and say that subject to closing the offer and confirming the details, the board should go ahead and allot shares to those that subscribe in accordance with the terms of the offer, something like that. I think that I recognize the issue, but I think that it's one that can be clarified with regulation. So I'm running out of time. Let me move to my next slide. The next topic I'm going to talk about is minority protection. I'm just going to flag two main points in relation to minority protection. In the strict sense of minority protection, Chapter 13 of the Cama, which is the chapter that has to do with protection of minorities against oppressive and fraudulent conduct, it has been amended. The major amendment is that the concept of a major asset transaction has been introduced. So what section 342 in chapter 13 says is that a major asset transaction is one in which there's a series of transactions which relate to the purchase or acquisition outside the usual course of business of a company, or the sale of outside the usual course of business of a company's property or rights, the value of which at the day when the company decides to go ahead with the transaction is 50% or more of the company's book value, assets book value. So where a company wants to either purchase any property or rights or sell property or rights which have a value that is equivalent to or more than 50% of the book value of the company's assets, that will be regarded as a major asset transaction. And for those transactions, the company can only enter into transactions of that nature if they have shareholder approval. What the Cama says is that the approval required from shareholders is a special resolution unless the articles state that it can be an ordinary resolution. So that's something to bear in mind as we structure transactions, that you might need, you need to check whether it constitutes a major asset transaction, and if so, if there are no provisions in the article specifically empowering the company to approve such transactions by ordinary resolution, you need to have the transaction approved by special resolution. There are some other minority protection provisions that have been included in Cama. So for instance, where a shareholder filed a suit.
Uzofu, sorry to interrupt, but you're running out of time. So I think you have 5 more minutes.
Okay, so let me leave other things minority protection. But what I wanted to flag in section 22A of the Cama is that it says that unless otherwise specified in the articles, the company cannot, without the consent of all members, sell assets having a value of more than 50% of the total value of the company's assets. The problem with 22A is the requirement for the consent of all members. This section doesn't relate only to private companies, it's all companies. And so for a PLC, just the practicality of getting the consent of all members seems like an impossible thing to achieve. However, there's out in section 22A because it says unless otherwise specified in the article. So what we would expect is for companies is that when they have an opportunity to amend their articles, to bear section 22A in mind and see whether they want to include provisions to limit or exclude the applicability of such restrictions on them. I'm going to move quickly to what's in it for SMEs. There's a lot of talk about how the Companies and Allied Matters Act is going to make things easy for SMEs and generally ease the process of doing business in Nigeria. So the objective behind a lot of changes in the Cama 2020 is to help SMEs focus on the business of growing rather than on the business of complying with regulation. So we want to make sure that their resources and their time and their efforts are channeled towards growing their businesses. Some of the initiatives to achieve this are single director companies available for all small companies, single shareholder companies, that's available for all private companies. But for private companies that are not small companies, they will need to have at least 2 directors. What are small companies? Small companies they've always existed. They were in the Cama 1990, but the net has been cast wider so that a lot more of our small businesses qualify as small companies. So let me just quickly mention what constitutes a small company. The turnover of a small company should not be more than 120 million naira. Its net asset value should not be more than 60 million naira. None of its shareholders should be foreigners. None of its shareholders should be government or government agencies or any of their nominees. And the shares of the company, the directors of the company should hold at least 51% of the shares of the company. So that's what will constitute a small company. So if any company that is a small company no longer needs to audit their accounts, no longer needs, and this applies to companies that have not carried out business since incorporation. They do not need to submit accounts along with their annual returns. They can just file their annual returns form. They do not need to appoint a company secretary. They do not need a company seal. This actually applies to all companies in Nigeria now, including incorporated trustees. They do not need to hold general meetings. This applies to single shareholder companies and small companies. And for private companies, all private companies, you can have your general meetings as virtual meetings. Just to mention that there was a gap in the law in relation to the framework for executing mergers on account of changes that had been made to the Cama 1990 and to the Investment and Securities Act, both acts over time, and finally with the passing of the Federal Competition Consumer Protection Act. But that gap has been filled up by Section 711 of the Cama that reintroduces the procedure for executing schemes of mergers with two major changes. There is no requirement for the court to refer the scheme to assess the fairness of the scheme, and there is no, and once the court sanctions the scheme is effective. So before it was when the court sanctions the scheme and the court sanction is filed at CAC, the scheme becomes effective. But if you execute a scheme under Section 711, it becomes effective. Maybe you have court sanction. My last point is in relation to companies limited by guarantee. There was a lot of interest in what has changed in relation to these sorts of companies. This is one of the structures available for non-profit organizations in Nigeria. The Attorney General of the Federation has a right to consent to any application that submitted for establishing incorporated trustees. This has always been the case under the Cama 1990. It remains under the Cama 2020, but there is a way for the CAC to go ahead and register companies even where the Attorney General has not consented or refused to consent. So if the Attorney General has 30 days to either consent or to refuse, he may ask for additional documents. And if he does, that 30-day period is postponed to, and it will start counting from when you submit the additional documents required. However, when the 30-day period is over, if you've not obtained consent, you can advertise in the newspapers, and subject to the CAC dismissing any objections that might be received, or if there are no objections, the CAC can go ahead and register the company. There was an increase in the amount of liability that members of such companies will have in the event of the company being wound up. The total amount of the members' liability used to be 10,000 naira. That has been increased to 100,000 naira. Again, a little bit of confusion. There's subsection 12 says the liability of a member is 100,000 naira, but subsection 14 says the total liability of the members is 100,000. So I think that that's something that will have to be tidied up over time. I'm going to stop here. We will take questions on anything I have discussed at the end of the session. Thank you very much.
All right. Thank you, Ozofo. Just to make a couple of comments in relation to how we're going to proceed for the rest of the webinar. The plan was for every speaker, every panelist to have 15 minutes. We're running a little behind on that, but we'll try and see if we can make up. I am keen to conclude this webinar no later than 3:30. So it's because I think it's important that people who have joined us for the afternoon know with certainty when they will when the event is going to conclude. So the event will conclude, even if it's mid-sentence. The event will conclude at 3:30. However, I expect that we will be in the middle of the question and answer session at 3:30. And the plan is to keep the webinar, or to keep the question and answer session open after the formal conclusion of the webinar. So if you are still interested and you have questions that haven't been asked, please feel free to stay with us for another half hour until 4, and we'll try and take those questions hopefully in a slightly more relaxed manner. So that's the plan. Next up is Christine Shijuade. Christine is a partner in the firm's corporate and M&A teams. And as I mentioned at the beginning, Christine was the chairman of, I think that's the term, of the drafting subcommittee. And Christine is a relative veteran of the firm. She's been with us for all of 13 years. Christine?
Thank you very much, Mr. Well, good afternoon, everyone. I'm going to start sharing my screen. There we go. I hope everyone can see my screen.
Yes. So, Christine, I will time you out at 15 minutes. Let's see if we can come in within that.
That's perfectly fine. Okay, welcome everyone. I'm going to start by talking about what's completely new in the Act. So in Cama 2020, there are now 2 corporate structures that have been recognized. These are limited liability partnerships and limited partnerships. Now, prior to Cama 2020, these entities were registered in Lagos State under the Partnerships Law of Lagos State. Now, while the legislative competence of Lagos State to enact laws was never in question, there was always an ongoing debate around the ability of state houses of assembly to enact laws essentially conferring limited liability status on entities. So this debate has essentially been put to bed by the enactment of Cama 2020 and the introduction of these two entities in the statute. And this is great because these 2 entities are fairly flexible. So for example, in relation to limited liability partnerships, they enjoy corporate personality the same way companies do. They can sue and be sued. They can own property in their own name. Now with limited partnerships, while they don't necessarily enjoy the same sort of corporate personality that limited liability partnerships enjoy, they have what's called a general partner who's liable for all the debts and obligations of the partnership, while the limited partner's liability is limited to the extent of his outstanding contributions to the entity. And these 2 entities are great because they are simpler to set up. They are simpler to dissolve. You just pass the relevant resolutions, quote and unquote, or you can have them wound up by the courts. They don't need to have a share capital. So that's great. And for private equity fund managers and even venture capital fund managers, these are the sorts of vehicles that they typically use when they set up funds in Nigeria. So it's great that there's a regulatory framework for them under Cama 2020. I'll now talk about what, in relation to existing entities, I'll talk about what's new and what has changed. So with respect to private companies and how you acquire shares of private companies, in Cama 1990, Section 22 said all private companies were required to restrict the transfer of their shares in their articles. Now that's changed. The section is still Section 22. However, the language seems to suggest that private companies may restrict the transfer of their shares and also provide for certain things. And there are 3 things. The first essentially works as a right of first offer, where if an existing shareholder is seeking to sell his shares to a non-shareholder, he has to first offer those shares to existing shareholders. The second is where shareholders who hold more than 50% are looking to exit. Whoever is buying those shares will have to offer to buy the shares of the remaining shareholders in the company. And the third is where the company is seeking to sell more than 50% of its assets. You require unanimous approval. Now, it seems that the thinking of the National Assembly in relation to this provision was to give shareholders a choice, whether they wanted to remain in the company or whether they wanted to leave. Hence these provisions. However, there's certain confusion that has that has arisen as a result of the drafting. It's not clear whether this is a mandatory provision the way it was in the articles, or whether it's optional. Either way, there's a way out, and that's the fact that shareholders or companies can specifically exclude these provisions in their articles. That's clear. So we anticipate that we may see a lot of companies seeking to specifically exclude these restrictions in their articles. Now, investors in particular will need to pay attention to this issue of what is essentially a takeover bid when they're seeking to acquire companies, because it could have an impact on funding and on transaction costs. So if, for example, you were going to buy shares and the shares were worth 5 million naira, if the shares of the remaining company will be worth an additional 5 million naira, you will need to think through how you will fund that acquisition. So just something for the market to think about. Something else that's changed a little bit is in relation to financial assistance. Now, financial assistance is essentially a process where the company provides assistance to persons who want to acquire its shares. Now, that assistance may be in the form of a gift, it may be in the form of a guarantee or a loan or some form of indemnity. Now, all of this was unlawful pre-2020, and the exceptions were very, very limited. So, for example, it was only permitted if you wanted to fund employee share schemes or if you wanted to give a loan to a director in certain specific circumstances. Now, in Cama 2020, the law has expanded the exceptions that are available. So a company can provide financial assistance to someone seeking to acquire its shares if it's being done as part of a court-sanctioned scheme of arrangements or a court-sanctioned merger or restructuring. So that's great. Another new exception is the fact that if the financial assistance is not being given solely for the purpose of extinguishing the liability that buyer would have incurred, but it's being done as part of a larger purpose of the company in good faith and in the best interests of the company, then it would be permitted. For private companies in particular, financial assistance is no longer unlawful where the private company follows a certain process, which is typically called whitewash. And here, the private company would need to pass a special resolution, that's the 75% threshold in value of the shareholders present and voting at a meeting. The financial assistance that's being given must not result in a reduction in the net assets of the company. But if it will, then the company must ensure that the assistance is being funded from distributable, available profits. And the third is that the directors will need to file a statutory declaration at the CAC. Now, the section doesn't quite say what the declaration should say. It says in the prescribed form. So we expect that the CAC will provide some guidance or will even provide the form that will be used for this purpose. In terms of benefits, this is great because for those who structure transactions in Nigeria, who invest in companies, there were certain elements of transactions that were quote and unquote questionable when we were looking at these deals. So for example, if the target company is going to provide indemnities in relation to how it has operated its business to date, there were always questions around whether that indemnity was unlawful. But now, given the exemptions that are available, those sorts of deal structuring elements will no longer be unlawful. Something else that was previously prohibited that's now permissible subject to certain conditions is the ability of companies to buy back their shares. Now, pre-Cama 2020, share buybacks were prohibited. The exemptions were limited. For example, and even those exemptions were not typically used in practice. So, for example, you wanted to settle a debt with an existing shareholder, or you wanted to eliminate fractional shares. Other than those specific exemptions, you couldn't buy, the company could not buy back its shares. Now it's permitted if certain conditions are met by the company. So, for example, it has to be permitted in the company's articles, and the company must approve it by way of a special resolution. Now, there are also limitations. So, for example, the company can only acquire shares that are already fully paid up, and it must be funded from distributable profits. The last is that there's a 15% cap on the number of shares that the company may acquire. When the company acquires these shares from its existing shareholders, those shares are called treasury shares. Now, this is a concept that existed in Cama 1990, but there wasn't quite a clear definition of this term. Now it's formally recognized in the definition section, and it's defined essentially as what it is, shares that a company has acquired from shareholders. And Cama 2020 also makes it clear what the company can do with these shares when it has acquired them from shareholders. So the company can sell it to third parties, new investors for cash. It can also transfer those shares to its employee share option scheme. Now, there are certain rights that those shares do not have. So even though the company will be registered in its register of members as the owner of the shares, it won't be entitled to voting rights, it won't be entitled to any dividend, things like that. Share buyback is great because once the buyback has been completed, it's beneficial for the company because it enhances the value of the remaining issued shares, or of the issued shares that will be remaining after the share buyback has been concluded. The last thing I want to talk about is things that will need to be taken into consideration when you are structuring certain mergers and acquisitions, in particular board dynamics that will come into play. Prior to Cama 2020, certain categories of persons were disqualified from being directors, obvious ones, a minor, an infant, or somebody who is an undischarged bankrupt. There's a new one in there, and that's someone who has been removed or suspended by the company. I know that a couple of practitioners, when we saw this, we were worried because we thought, what happens if an executive director has been removed by the company? Does that mean he's precluded from acting as a director in any other company? And going by the provision of the law, the answer to that is yes. But there is a solution. The solution being that parties can negotiate and agree that rather than being removed, the director can choose to resign. So that will always be something that will need to be discussed at board level and even with the shareholders. The second is the exclusion of the chairman's vote through the articles. Now, pre-Cama 2020, at board meetings, if there was a decision and there was an equality of votes in relation to that decision, the chairman had a casting vote to break the tie. Now, Cama 2020 says that this chairman's casting vote can be excluded in the articles. So essentially, this will sort of act as veto rights where if there's a tie or if there is a director who has a veto power, all of this can be covered in the article. So that's something for people to pay attention to. Now, the casting vote still applies in general meetings. So if there is a tie at a shareholders meeting, the chairman still retains the casting vote in those circumstances. That Cama 2020 does not permit the articles to exclude that or disapply that. And then the casting vote also still applies at board committee meetings. So when we're structuring deals, we'll need to take these board dynamics into consideration. I'll stop here. I can see Mr. Agbo fidgeting a little bit. So I'll stop here. We'll take questions at the end. Thank you.
All right, Christine. Thank you very much, Christine. It must have been a Freudian fidget. Right on the dot of 15 minutes. So thanks. That was really, really very interesting. Next up is a lady that I always want to have with me when I go into battle. And the way I would describe Oyinda Ehiwere, who is the Chief Executive Officer of Allsec Nominees Limited, which is the company secretarial arm of the firm. And the way I think of Oyinda is, just to use a golfing analogy, when I hit my golf ball, and by the way, I don't play golf, if you hit a golf ball into the long grass and you're desperately trying to find the ball, Oyinda is the person that will help you find that ball. I know few people who know their way around the minutiae of the Companies and Allied Matters Act 1990. I know few people who know their way around those details like she does. And she has begun the process of finding her way around the Companies and Allied Matters Act 2020, and is going to share some of those things with us. Not so much from the big point of view of the big fancy stuff that Ozofu and Christine have talked about, M&A, share buybacks, my golly. It's more in terms of the detail, the things that affect small shareholders in their day-to-day use of the statute. So, Oyinda.
Thank you, Mr. Agbo. So I'll be taking you through public company governance, disclosures and transparencies, electronic innovations, and a little bit of changes that have been made to incorporated trustees in the legislation. In terms of the public companies, I'm trying to share my screen.
You know, while Oyinda is doing that, and sorry, I omitted to say this, just to complete the introductions, Oyinda has been with Allsec Nominees Limited, which is the company secretarial arm of our firm, for 15 years. So another lifer. Ozofu, one of the things while Oyinda is being guided in this, and Oyinda, while you're getting ready, and we'll give Oyinda a little bit of time. Ozofu, one of the things that you didn't talk about was the process that led to this statute. Do you want to spend 2 minutes, and I mean 2 minutes, do you want to spend 2 minutes telling us about the process that led to the enactment of this piece of legislation?
Yes. So in 2016, the section on business law, the NBA section on business law, was asked to assist the CAC in coming up with a draft bill to amend the Companies and Allied Matters Act. So several law firms members of the MBSBL contributed to that process, including Uubo and Belo-Osagie. After that, there was a peer review of a document that had been generated by Professor Idonije panel. And the peer review, that peer review was sponsored by DIFL Enable, GEMS 3, and the Office of the Senate President. That peer review process flagged the Companies and Allied Matters Act as one of the key statutes that had to be amended in order to really drive the growth of business in Nigeria. I think it was after that process that the Senate President's office really took focused on getting the Cama amended. So I was also involved in that process. So after that, in May 2017, the Senate set up a technical advisory committee and asked me to chair it. And that committee comprised members of the MBA section on business law, the Corporate Affairs Commission, the NIPC, PEBEC, Ministry of Justice, so various stakeholders, to look at various acts that were already before the National Assembly for amending the Cama. The acts were not extensive. Some were very small. I think one was maybe 3 pages. So no extensive amendments were proposed. But so what our committee did was take all the various bills that were making their way through the National Assembly, including the input that the MBSBL had provided in 2016, and generate a bill. That bill was submitted in February 2018 to the President of the Senate. it eventually got passed by the 8th National Assembly, but did not receive the president's assent. So another bill, very similar to the bill we submitted in 2018, but with amendments, was submitted to the 9th National Assembly. And that was passed and then assented to by the president on the 7th of August. So I saw a question. The bill you submitted, is it the same bill that has now become the act? So I guess I've answered that question. No, it's not. But the bill we submitted was the base document, and then that went through the legislative process and was further amended, and then we got what came out as the Cama 2020.
Okay, so thanks, Uzo. For that context, I think will be useful come the Q&A, because I've already seen some questions that have been raised. Oyinda, are you set? Are you? I think you're still on.
Yes, Mr. Abo, I'm set. I'm good to go.
All right, let's go.
In terms of electronic innovations, the new Cama is totally new in terms of that. In terms of new innovations, the new Cama is totally new in terms of that, because before the advent of the Cama, CAC was not accepting electronic signatures at all. Now they have said documents could be signed electronically and can be uploaded electronically. Prior to the introduction of Cama 2020, notices of meetings were required to be provided to directors, shareholders, by personal post, served on them by personal post or by mail. But with the Cama 2020, notices are now allowed to be sent by email, electronic mail to the directors. The companies are now allowed to keep electronic copies or register of any documents required under the Act in electronic forms. And most importantly, documents that are required to be annexed to the annual return of companies can now be submitted by electronic communication to the Corporate Affairs Commission. This is particularly a great development, because I remember that during the COVID, we were struggling a lot with getting directors of companies to sign documents for us. And the question was always, oh, can we sign electronically? And we still had to say then during the COVID, and which is still on then, that the CAC has not started accepting electronic signatures. So this is a good development, and it's going to help a lot of companies in their submission of documents to the Corporate Affairs Commission. Thank you. The other innovation has to do with public companies and governance. Sorry, I seem to have missed the slide. The public companies and their governance. Before the introduction of Cama 2020, we had only been hearing about companies having to appoint independent directors, independent non-executive directors through the Code of Corporate Governance for various industries. But the Cama 2020 has now codified this and has prescribed that public companies should have at least 3 non-executive directors on their board. Not only that, the Cama prescribes that where there's a core shareholder on the board, the core shareholder could appoint the independent non-executive director. What I've found a bit odd about this provision is that it says, provided that the INED, if his company, if he has relationship with the company already, he should not own more than 30% of the shares of that company, whether directly or indirectly. And I rather thought that's a huge threshold. I mean, if you compare it to Nigerian Code of Corporate Governance. In the codes before now, we have always seen chairman of a public company not to act as CEO. So the Cama has codified this now, and no chairman of a public company can act as the CEO or the managing director. In terms of the audit committee, the Cama 1990 section 359 provided that public companies shall have audit committees with equal number of shareholders and directors. And so it also allowed that you could have an audit committee of 4, minimum of 4, maximum of 6. But Cama 2020 specifically says your audit committee should be composed of just 5 members, 3 of them shareholder representatives, and 2 executive directors. Unfortunately, the Cama has not provided a way out for public companies how they would get to that position, because some companies have held their AGM this year prior to the introduction of the Cama 2020, and they have already appointed 6-member audit committees. So that's something that probably the regulation that the CAC is going to issue is going to deal with. In Cama 1990, we had a provision that prescribed that a substantial shareholder, a shareholder who has up to 10% of the shareholding of the company must notify the company. In Cama 2020, this threshold has been reduced to 5%. In terms of multiple directorships, the Cama 2020 has now prescribed that a director of a public company should not be on the board of more than 5 public companies. And the Cama further provides that where a director is on the board of more public companies than 5, then within a space of 2 years, that must be reduced to not more than 5. The Cama has also, provided that where a director is going to be appointed to the board of a public company, then he must disclose at the meeting at which he's going to be appointed his directorships of other companies. This was not a provision that was in Cama 1990. At best, we had just conflict of interest, but it didn't include this multiple directorship. A person could be a director in as many companies as possible, just that there were guidelines that he doesn't use one information he gets from one company to the benefit of another. But it didn't stop him from doing that, and there was no requirement to disclose at a meeting which companies he was on. In terms of disclosure too, Cama 2020 now provides that the remuneration of manager should be disclosed at the annual general meeting as an ordinary business of the AGM. That means that going forward, as company secretaries are drawing up their notice of annual general meeting, then they have to remember to include remuneration of managers as part of the ordinary business of the AGM. Public companies are now also required to display their audited accounts on their websites. I believe this is actually just a codification. This is a requirement of the Nigerian Stock Exchange rules, and most public companies have been doing that. But the Cama now codifies that and makes it mandatory. The Cama 2020 also now provides that accounting statements by public companies should include statement of changes in equity. That's new. That's a new provision. It was not in Cama 1990. For companies generally, the Cama 2020 now provides that a list of unclaimed dividends must be published in 2 national newspapers. This requirement was not there before, so it's a new requirement. It's a cost implication for most companies, and it is not restricted to public companies. It's inclusive of private companies, and every company then has to comply. Significant control is also a new introduction in Cama 2020. The Cama 2020 provides that where a shareholder acquires significant control, he needs to notify the company within 7 days of that acquisition, and the company in turn needs to file a notification to the Corporate Affairs Commission. And the Corporate Affairs Commission is also now required to maintain a register of significant control in companies that have been filed with it. In terms of incorporated trustees, a lot of changes were made in the legislation. My thoughts are these changes were made to promote transparency and accountability in this part of the Companies and Allied Matters Act. A lot of implementation to the provisions that have been added will have to depend on the regulations that the Corporate Affairs Commission is going to issue. I looked through that section, and almost every statement had to do with in line with the regulation, in line with the regulation. I found it interesting that one of the provisions that has been made there is that the CAC is going to classify associations in line with their aims and objectives. I don't know how they're going to do that, but I look forward to seeing that done. We know that incorporated trustees, you have a lot of not-for-profit entities under there. But what has been made more cumbersome for them is the fact that they'll now be required to file biannual statement of affairs at the Corporate Affairs Commission. Hitherto, they were required to file annual returns at the CAC. Companies regulation had provided that they would file the annual return with their audited financial statement. That wasn't in Cama, it was just part of the regulation. But with the new Cama, the Cama has now codified the inclusion of the financial statements with the annual return that is to be filed by an incorporated trustee. And like I said, it has further provided that incorporated trustees must file biannual statement of affairs. So it's more onerous reporting procedure or responsibilities for them. Worthy to note is that hitherto in Cama 1990, one person could be a trustee for an incorporated trustee. But Cama 2020 now provides that 2 or more persons, no longer 1 or more persons. So it's 2 people to form it. And it also provides that it's the Corporate Affairs Commission that will determine the financial year of the incorporated trustee. Interestingly,
sorry to interrupt, but you have 2 more minutes.
Okay, Mr. Wu. Interestingly, the new Cama 2020 has also made provision for mergers of 2 or more associations. That's interesting because in 1990, there was no such provision. Associations could not merge. It's also provided for specific accounting records to be maintained by the incorporated trustee. And it has also provided that those records must be maintained for 6 years. The association must maintain its records for 6 years. The really big introduction is the fact that the CAC can remove the trustees of an incorporated trustee and appoint an interim manager to take over the affairs of the incorporated trustee. Thank you.
All right. Thank you very much, Oyinda. I suspect there's going to be an active conversation around this last slide, and we can probably take it after we formally most of the questions after we formally close. But the next up is Onye Okafor. Onye is a partner in the firm's banking and finance practice. And certainly one of the best banking lawyers that I have known. She's been with the firm 15 years. And I know of nobody that can process 600-700 page loan documents like Onye can. I know of nobody else. So Onye is going to be talking really around two or three points that would be of particular interest to a banking lawyer in the newcomer. Onye, over to you.
Thank you, Mr. Abo. So I'm going to be talking about registration of security under Cama 2020. Oh, sorry, I need to share my screen. Can everyone see my screen?
Yes.
Okay, thank you. So I'm going to talk about 3 points, as Mr. Abo mentioned: registration of security under Cama 2020, company rescue procedures, as well as the netting provisions. So I'll start with registration of security under Cama 2020. The Cama 2020 introduced the new subsection, which has significantly reduced the cost of registration of charges at the CAC. This subsection limits the total fee payable in respect of registration of charges to 0.35%. It is a significant reduction considering that prior to this enactment, private companies pay 1% and public companies pay 2% in order to register security they create over their assets. The second thing I'm going to talk about is in relation to negative pledge. A negative pledge is a restriction in a floating charge instrument, which prevents a company from creating a subsequent charge that has priority or ranks pari passu with the initial floating charge. Now, under the previous Cama 1990, a floating charge, a holder of a floating charge will only be able to retain its priority in relation to a subsequent fixed charge. If the floating charge instrument includes this negative pledge restriction in the relevant instrument, and the holder of the subsequent fixed charge has actual notice of that undertaking. For evidential purposes, it was difficult to prove when a party has actual notice of the existing prohibition. So the amendment introduced now is that once a floating charge holder registers this prohibition at the CAC, a holder of fixed charge is deemed to have notice of this prohibition. So actual notice has now been dispensed with. In addition, the CAC now requires, the Cama, section 2232 of the Cama now requires the CAC to also include as a particular of charge this negative pledge in its register of particulars of charges. And now, the new provision on security expressly provides that registration of charges constitutes constructive notice of the matter specified on the particulars of charges. Another amendment to the security provisions of the Cama 1990 is the introduction of the definition of book debt. A charge over book debt is one of the registrable charges, both under the 1990 Cama and the Cama 2020. However, the 1990 Cama did not define book debt, and this sort of created challenges over whether, in relation to whether a charge created over certain instruments such as treasury bill or commercial papers, whether security created over such instruments are required to be registered as book debt under the Cama provision. Now, the book debt has now been defined in the Cama 2020, and it now excludes marketable securities and negotiable instruments. So what this means is that where security is created over instruments such as treasury bills, those instruments will no longer be required to be registered under Cama. Another amendment or innovation of the Cama 2020 is the introduction of the concept security financial collateral arrangement. It introduces and defines security financial collateral arrangement, and then goes ahead to exempt this arrangement from the registration requirements in Cama. So the implication of this is that security now created over financial collateral such as bank deposits and securities will be exempt from the registration requirements. You will agree with me that this is also a welcome development. Moving on. The other point I'm going to talk about is introduction of company rescue procedures. So when a company is undergoing financial difficulties or nearing insolvent or even insolvent, there are other procedures that the company can access in order to ensure that the company continues as a going concern. So this is one of the innovations of the Cama 2020. It introduced two procedures which were not previously in Cama 1990. The first is company voluntary arrangement under Chapter 17, and the second is administration under Chapter 18 of this Cama. So under the company voluntary arrangement, a director can make a proposal to its creditors for a composition of its debt and a scheme of arrangements of its affairs. And in addition to this, an administrator can also make this sort of proposal where the company is undergoing, when an administration order is enforced. A liquidator can also make this proposal where a company is undergoing winding up procedures. So those three people can make proposal to the creditors to settle their debts. So essentially, it is a process by which a company settles a proportion of the amounts payable to its creditors, as well as sort of agree other arrangements by which it would pay off their debts. Now, the purpose of this is to call a meeting of the creditors in order to agree the terms of the proposed voluntary arrangement. Once this is agreed and presented before the courts will approve it. And the effect of a court order here is that it binds all the persons entitled to vote, whether or not they vote, as well as other persons that would have been entitled to vote had they received the notice. So I'll go quickly to administration. Administration again is. Sorry.
Yeah, I wonder whether you may not want to because administration itself is probably a significantly substantive subject. Maybe you want to talk about netting before so we have at least 10 minutes for the Q&A before we close.
Okay, Mr. Uubo. Okay, I'll jump right into netting. So netting is one of the key innovations of Cama. The Cama 2020 introduces netting provisions, which is now currently section 718 to 721 of the Cama. Now, the objective of this netting provision is actually to provide legal certainty to financial institutions that enter into financial contracts. These financial institutions require a high degree of legal certainty in order to effectively manage their risk. I'll try to explain further. So you know that when parties enter into contracts and one party becomes insolvent, what happens is that the solvent party will be required to meet its payment obligations under that contract, whilst queuing behind the other unsecured creditors of the insolvent party. So this way, you may have access to little or no funds to sort of reduce its liabilities. Now, how does netting come in here? Netting sort of tries to address this risk by aggregating the obligations of the parties and offsetting them against each other so that only one net payment will be due from either of the party, which would be the party that has the larger obligation. So I'll try to give an example. So if, for instance, two companies, company A and B, enter into, for instance, let's say 10 contracts, and company A is owing, or company A owes money in relation to the first 5 contracts, while company B owes money in relation to the last 5 contracts. So what happens in insolvency of, let's say, company B is that when company B becomes insolvent, company A would have to pay all the amount it owes company B in relation to those 5 contracts. But in relation to the amounts owed company A from company B on the other 5 contracts, it will have to queue up to share in the assets of the company, queue up with unsecured creditors. And as you can imagine, if the insolvent company B has already created security over its assets in favor of some secured creditors, those secured creditors will have to take first. And then whatever is remaining would be what will go to the unsecured creditors. They will share it proportionately. And as you can imagine, it's possible that company B may have will not even have access to any funds at all. So, but if netting law is applicable, what then happens is that instead of company A paying all the amounts due under the 5 contracts, what will then happen is that the contracts will be aggregated between company A and company B. Once they are aggregated, they are offset against one another so that one net obligation is due, and that is the amount that either of the party will pay to the other party. This would sort of reduce the liabilities in relation to any of the parties. So it's a good thing that so it's one of the ways that netting addresses financial risk. Now, although I should mention that prior to the enactment of Cama, the parties were able to rely on the insolvency set up under the Bankruptcy Act in order to address this issue. So the insolvency setup itself has provisions where parties are able to offset their liabilities against each other. However, because of the restrictions in effecting this insolvency setup, it was unclear in certain scenarios whether all forms of netting, whether the court will recognize all forms of netting as set up under the insolvency provisions. And like I said, parties require legal certainty in order to address this issue. Coming to enforceability of closeout netting itself. So closeout netting is just a provision in a netting agreement or in a financial contract which provides that when certain circumstances happen, that so one of the circumstances, which is even the critical one, is the insolvency of one of the counterparties. So when this happens, the solvent party is able to terminate all the contracts that both parties have entered into, terminate all those contracts, value the contracts at the replacement cost, and then convert to one currency, and again offset it to have one payment obligation. So this is all good when there's no insolvency, but post-insolvency, there's this risk that the mandatory insolvency provision, like fraudulent preference, could potentially disrupt this. And as I said, parties require a high degree of certainty in order to ensure that financial contracts which they enter into would be enforced. And if this provision is not enforceable in the insolvency of one of the parties, it could lead, in fact, it will lead to increased liabilities and costs for the solvent parties. So it is necessary to protect the obligations under this contract, and to do so, we need clear provisions that sort of says that these contracts will be preserved and will be enforced in the insolvency of any of the counterparties. Hence, the reason for a netting provision. And so with this netting provision, international financial institutions, foreign institutions, international finance banks will be encouraged to invest more in Nigeria. Because, this financial institution, international banks, they have financial exposures which they would like to manage, and they would rather go to a country where they know they are able to manage this risk. And so, where as we have netting law today, they will be encouraged to invest more in Nigeria, knowing that we have netting law, and that their transactions would be able to be enforced if the Nigerian counterparty becomes insolvent.
I think we need to wrap at that. Okay. We have literally six more minutes for Q&A before we wrap the webinar.
Okay.
So listen, thank you very much, panelists. We'll just go straight to the Q&A. I have a number of interesting questions have come through, and I will nominate members of the panel to respond to the questions. So the first question, and we'll take as many as we can during the before 3:30, and then we'll continue afterwards. So the first question is from Mr. Uwechia. He asked two questions, and the first is, what is the, and I'd like Ozofu or Christine, whichever of you let's say Ozofu. What is the effective date of the Act is the first question. Ozofu?
Okay, so because the Act doesn't specify an effective date, it is supposed to take effect the day it was signed by the President, which is 7th of August, 2020. I think that, so there was a version of the Act that was circulated, but it's not, it doesn't have the President's signature, and it also has some missing pages in the scan. So I think for just to be cautious, people are waiting for the gazetted copy, but we don't expect that the gazetted copy will say anything other than will state another effective date. The date of gazetting is not the effective date, unless the Act said so. So the Act is in effect, but it has not yet been gazetted, or if it has, a copy has not yet been published or made available to the public. And we've checked this with the CAC. We know they're chasing up on this, but as far as we are aware, the Act is in effect since 7th of August. Okay.
Ms. Uche also asked a general question on whether slides and a recording of the webinar would be made available after the session. In relation to slides, everyone who registered, the copies of the slides will be emailed to everyone who registered. And in terms of the recording is going to be uploaded on YouTube, and I think also on Instagram, but certainly on YouTube, and it will be available for participants and anybody else who's interested. Bayo Dubeko asked, Christine, this for you. Bayo Dubeko asked whether Cama 2020 regulates related party transactions for both private and public companies.
Okay, so this is something that is typically regulated by companies by themselves. So what Cama regulates is major asset acquisitions, and then it goes on to say you need a special resolution for that, or in your articles, if you prescribe an ordinary resolution, then that's what is required. So it doesn't deal with...
Sorry, Christine, I interrupted.
No, okay, I had finished.
Okay. Thanks, Christine. This one's for an anonymous question, but I will raise it with Ozofu, since she dealt with this particular subject. And the question is, what mischief was the amendment doing away with the concept of authorized share capital and unissued share capital meant to cure, especially in view of the complexities the amendment has created for public companies, as you have pointed out?
Okay, so as I said when I was making the presentation, the mischief that he tried to address was two-pronged. One was the fact that the authorized share capital was not regarded as a real representation of the capital that had been put into the company, or because as I had illustrated, it was possible to have a company with authorized share capital, issued share capital, and no paid up capital, so no capital could have been put into the company. In relation to, so the second point is front loading of costs, and that was really driven by the ease of doing business initiative behind this bill. So to ensure that parties only have to pay for share capital when they want to issue it, rather than having to create it and hold it as a reserve. So that was the mischief behind it. Now, in relation to complexities it has created for PLCs, I acknowledge that those complexities have arisen. These are early days. There will be regulations, and there will be a lot of engagement between participants in the market, companies, and the CAC. And I'm very confident we'll work it out. But I think on the balance, we should move forward and not be put off by the complexities that will arise as we embrace new things.
So I'm really fascinated by some of the questions that have been asked, and I suspect that it will be impossible to do justice to them in this session. So one of the things we will commit to everybody who signed up for this webinar is that we're going to collate the questions and answers. There will be a certain amount of duplication. We'll collate the questions rather, and we will do a Q&A that addresses those questions and send round to everyone. It does two things actually. One, it addresses your questions, but it also, I think, encourages us to look at things that we might not have otherwise looked at, since we're a little close to the process. Another question that has been asked, and I'll pose this question to Christine. This question was asked by Mr. Rotimi Oyekomi, and he says, I assume the new rules enforce drag along for acquisitions of over 50% stakes. How can a company avoid this by not including this in their articles? I would have thought it would be for the shareholders to decide if they want to be dragged or not. And then he says, can a company reject this clause if in Cama? So Christine, any thoughts on that?
Yes. So what the Act says, it doesn't operate as a drag along. It actually operates as a tag along, where shareholders can choose to sell their shares when the majority shareholders are exiting. And yes, the company can choose to exclude this in their articles. Yes, they can.
Okay. Listen, ladies and gentlemen, I said we would wrap on the dot of 3:30, and we are going to wrap on the dot of the formal part of the webinar on the dot of 3:30. As I said, we will keep the webinar open for another half hour, and so we can continue with the questions and answers, but we will wrap in a minute. First, I'd like to thank everyone who joined us today. At its peak, we had over 600 participants on the webinar. And even now, the number of participants is still north of 500, about 530 odd. So it's great that so many joined us and that so many have stayed. A couple of things here. just remember what I said at the beginning. This is a really big piece of legislation. And legislation, particularly in a presidential system of government, but I would imagine in any system of government, is always a compromise. And compromise means that you get in stuff that is useful, and other people get in stuff that is not so useful, okay? And so it inevitably means that there's going to be stuff in the statute that has to be adjusted, stuff that doesn't work. It can be fixed. And the way to fix it is for everyone out there who is unhappy with the legislation as it is, to engage with your congressmen or members of the National Assembly, anybody who you know is going to be able to initiate the process of amendment. That process can start today. So just to talk about Cama was amended 4 times. So it's not like Cama was cast in stone. And I have no doubt this particular statute is going to be amended as well as time goes on. In the meantime, look for us online. Google us. We're on Instagram. We're on YouTube. We're on we're on Facebook. Every social media platform that you can think of, we are there. Thank you for joining us, everyone, and stay safe. Okay. We'll give it a minute before we segue to the informal, or rather less formal part of the Q&A and take whatever questions we were not able to answer. Thank you all very much, and bye. Christine, so one of the questions that was raised by Anonymous is, the question reads, on the framework for mergers, what is the process like now that there is no SEC, FCCPC workstream?
I think that question should be for me, because I spoke on my
Okay, apologies. Okay,
yes, no problem. Yes, I saw the question. So the answer to that question is, the regulator for mergers and acquisitions right now is the Federal Competition and Consumer Protection Commission. So that's the FCCPC. They regulate mergers and acquisitions. They've taken over that role that used to be exercised by the Securities and Exchange Commission. However, the Securities and Exchange Commission continues to regulate public companies and capital market operators. So if such entities wanted to enter into a merger or acquisition that crossed relevant thresholds, they would also need to go to the SEC for approval. If the company that is involved in, any of the companies involved in the transaction is a regulated entity, they might be required. So depending on the sector, if it's a bank or insurance company, telecom company, they may require sector regulator approval. So it's not like M&A transactions have no regulator at all. The CAC, to correct a statement that was made in that question, the CAC does not regulate M&A transactions. They are only, the only role they play in relation to mergers and acquisitions is for filing. So in a merger, you file the court sanction at the CAC, but that's it. They don't act in a regulatory capacity in the framework of mergers and acquisition transactions. I think that answers that question.
All right, thanks, Ozofu. So, Christine, let's see if I get it right this time. Another question from Bayo Dubeko, who asks, is it clear now that financial assistance does not apply to a primary transaction where a company is providing warranties and indemnities to the subscriber/investor? Okay.
Thank you. I saw the question and I had some time to think about it. And I certainly think that it's clearer now. And that's because of the exception that says the assistance will not be unlawful, where the principal purpose is not to reduce a liability that the investor would have incurred, but rather it's being done as part of a larger purpose for the benefit and in the best interests of the company and in good faith. So if that warranty is being given in the best interest of the company, so for example, the company needs funding and an investor is willing to make that investment, that warranty is being provided in good faith in the best interests of the company. So it's arguable that yes, in these circumstances, it would be lawful.
Okay. Thank you, Christine. Another question, I think this is for you, and the question is from Anonymous. It says, on treasury shares, are the limitations regarding dividend and voting rights lifted when the shares have been sold by the company?
Yes, that's right. So those limitations only apply for as long as the company is holding those shares. And it makes sense, right? Because you don't want the company to essentially be apportioning a portion of the dividends back to itself. But once those shares are sold to an investor, then those shares have the rights that would automatically attribute to them. So the right to attend general meetings and vote, the right to dividends, all of those would automatically come back into play when they're sold to a new investor.
Okay. So, Christine, stay where you are. Another question for you from Bayo Dubeko, who asks, why is buyback limited to 15%? And can this be made out of the proceeds of a new issue? And then he also asks, is 15% for both private and public companies or just for public companies? And how does this align with the SEC rules / Investment Securities Act 2007 in relation to public companies?
Okay. So I'll try to answer them all together.
Happy for you to answer this now, but if it requires a little further, we can deal with it in the subsequent Q&A we send around. Okay,
that's fine. So I'll answer some of them. So in relation to public companies, that 15% threshold has always been there. That's not new. Even in Cama, the 15% cap has always been there. That's not new. So the SEC rules just made it clearer that it applied to public companies in their rules. Now, we're not quite clear on what the thinking is for retaining this cap. Presumably, it's just to ensure that the company is not holding the bulk of its shares and is holding just a small portion, which 15% would logically represent. I'm trying to remember what the other questions were in there.
He asks, how does this align with the SEC rules, Investment Securities Act 2007?
Okay, so I think I've sort of responded to that in saying there's no inconsistency. It's in the SEC rules that the 15% threshold was prescribed, so it aligns quite well.
Okay. I see an interesting question on the Q&A tab, which I will pose to Ozofu, and it's from a T. Alao. I wonder if T. Alao is Theophilus. And if it is, a shout out to our good friend Theophilus. And if it isn't, a shout out to Mr. T. Alao. And the question reads, I read an article on the newly enacted Cama, which I am yet to confirm anyway, that there is a private association by the name of Business Recovery and Insolvency Practitioners Association of Nigeria, BRIPAN, that is included in the Act. And he asks whether that is, or he or she asks whether that is an oversight. Ozofu, would you care to comment on that? Because it is clearly one of the things that
yes,
that has been the subject of some comment.
Yes, thank you. I'm going to comment on that. In fact, I wanted to just project that provision. So, Section 705, it's the provision that deals with the those persons that are qualified to act as insolvency practitioners. Under the previous Cama, the qualified persons were legal practitioners and accountants, essentially. But 705 has expanded the qualification criteria so that others can qualify. And so there is, as you see in 705A, there is any person who has obtained a degree in law, accountancy, or other discipline from a recognized university or polytechnic, has a minimum of 5 years post-qualification experience, and is authorized to act as an insolvency practitioner by membership of BRIPAN or membership of other professional body recognized by the Commission, and holds an authorization granted by the Commission. So I think most of the agitation around this provision has been that whether everybody that wants to act as an insolvency practitioner, including lawyers and accountants, have to become members of BRIPAN. So the answer is no, because in 7051C, it's clear that members of other professional bodies recognized by the Commission can act as insolvency practitioners. I expect, again, that in the regulations that will come out, or in statements that the CAC will make regarding this issue, they will confirm lawyers and accountants who have traditionally carried out this role, and we belong already to recognized associations. There is some concern about the specific mention of BRIPAN, and I can understand that concern. Again, as we said, these are early days. There will be engagements on this issue, and I think all the provisions that are of concern, I certainly think we should continue engaging on them and see how we can get those addressed. The other thing I would say on this issue before I take down the slide is D, hold an authorization granted by the Commission, which means that in order to act as an insolvency practitioner, you do need to have some sort of authorization from the CAC. That is new.
Thank you, Osofo. Onye, we have one, we have essentially a request rather than a question by someone who would like you to give a brief summary of the administration section that we rushed through in your presentation. So just to give you time to call it up, we'll see if we'll deal with one question just to give you time to call up that part of your presentation. So at the end of this question, we'll come back to you. At the end of the next question, we'll come back to you and give you a few minutes to talk about administration. So I see two anonymous questions that I will raise with Oyinda. And the first is whether electronic notices can also be given to shareholders for general meetings. And maybe if you could address that in terms of public and private companies separately. So Oyinda, that's for you.
Oh, thank you, Mr. Agbo. The Cama did not make any distinction between private companies and public companies with respect to that. So it can be notices of meetings can be circulated to shareholders by electronic mail for public companies.
Okay, excellent. And then another question, somewhat related, by another anonymous attendee was whether the rule on the CAC receiving notices of meetings applies to board meetings as well as to general meetings.
Yes, it does.
Okay.
Both board meetings and general meetings.
Okay, excellent. Onye, you want to take a couple of minutes to just talk about the administration provisions?
Okay, Mr. Abo. So administration, as I mentioned in the course of my presentation, Cama 2020 introduced two company rescue procedures. I've talked about company voluntary arrangement. The second one is in relation to administration. So generally, administration is another company rescue procedure for insolvent companies experiencing financial difficulties, which allow them to carry on their business as a going concern. Now, in relation to an administration, the Cama provides that an administrator can be appointed by an administration order of the court, by the holder of floating charge, and by the company or its directors. The objective really of an administration is to rescue the company in whole or part of its undertaking as a going concern. One other objective would be to achieve a better result for the creditors as a whole, better than what would have been achieved were the company to go through winding up procedure. Another objective of this administration really is again to realize the assets of the company in order to distribute them to the secured and preferred creditors of the company. The provision actually states that the primary objective is actually to rescue the company as a going concern. So if the only reason the other objective becomes applicable is where the administrator believes that it is impracticable for the first objective to be achieved, and where it feels that it will be harmful, it will not achieve a good result for the creditors as a whole. So that's really the objective, to rescue the company as a going concern. In addition to this, there are restrictions on appointment. And one of those restrictions is that a person cannot be appointed as an administrator unless the person is entitled to act as an insolvency practitioner under Cama. One other restriction is that a person can only be appointed an administrator or rather, a person will not be appointed as an administration of a company already in liquidation, and this is by virtue of a resolution in relation to a company voluntary winding up and winding up order in relation to winding up by the court. Other provisions in relation to this administration is in relation to how the administration ceases. An administration ceases automatically at the end of 1 year after the appointment of the administrator. Now, the administrator can apply to the court for an extension of its duty. In addition, cessation could also happen by the creditors applying to the court to terminate the administration, and as well as the administrator itself applying to the court for termination of its rule. I think this essentially summarizes the administration provision of Cama.
Okay. Thank you very much, Onyinye. I see a request here from an anonymous attendee who has asked if we can share a link to a website that contains the full new Cama wording, then in brackets, ideally also available as a PDF. Osof, you want to comment on why on that and what the current challenges are around that?
Yes, so like I said, a few days ago, I think toward the end of last week, we actually published, I think when the act was just signed, we published an announcement, and it included a link to the current version of the act that is available, and that's available on our social media platforms. So whoever is interested can check that announcement and click on the link. But as I mentioned before, this document is the copy of the act that was submitted by the National Assembly to the President. It was signed by the Clerk of the House, but it is not the version that has the President's signature. And so we're still awaiting that. We understand that it's in the process of being gazetted. It may take a few weeks, and we just have to wait till then. But all our sources have confirmed that this version we have is what was signed. And so we are, with this presentation and everything we've done in relation to the Cama 2020 has been in reliance on the version that was signed by the Clerk of the House. And we just have to wait till the gazetted copy is made available. But it's available. A link to this version is available on our social media various handles.
Yeah, and this for the gentleman or lady who asked, if you can't find it, send an email to Ozofu. It's first name dot last name at uubo.org. Say you were the person who requested, and she will send you the link. We have a question from a gentleman named Gabriel, and I apologize if I mispronounce your surname, Gabriel Emiasoba. And he says, I guess Oyinda skipped the issue. Oyinda, this is for you. I guess Oyinda skipped the issue of the provision of electronic meetings for private companies. Does it mean that this electronic window is not allowed for public companies, especially small public companies? And I asked, what could be the rationale for the limitation of electronic meetings to private companies? I do believe you've already commented on it, but I think this is one of those ones that there's no harm in reinforcing.
Okay, so the Cama 2020 provided that private companies could hold their AGMs virtually, subject to the provisions in their articles of association. It excluded public companies, whether listed or unlisted. And also to generally comment that the Cama did not differentiate between listed and unlisted public companies. So only private companies can hold their annual general meetings virtually. My take on why public companies were excluded, it's probably because of the sheer number of shareholders that they have, and the fact that the bulk of the shareholders of a public company might not be technology savvy, as most of us that are on this call. So I think that's just it. And the CAC, the Cama is still saying those companies still have to hold meetings physically and by proxy if it's possible, or if the shareholder can attend by himself.
Okay. Thank you, Oyinda. Thank you. A sort of a related question, and from an anonymous, is the question reads, in relation to virtual meetings, must the AGMs of private companies be held in Nigeria?
Mr. Agbo, there is a provision in Cama, it was in Cama 1990 and it's still there now, that annual general meetings must be held in Nigeria. Annual general meetings and statutory meetings must be held in Nigeria. So my take on that would be that yes, the annual general meeting of a private company that is being held virtually, then whoever is hosting the meeting should be in Nigeria.
This is the first question I have. When you say whoever is hosting the meeting, what does that mean? Are you talking about whichever technology provider is hosting the meeting, or whichever company secretary has arranged the meeting? What do you think that actually means?
My take is whichever company secretary has arranged the meeting.
Must be
based in Nigeria, must be in Nigeria.
Okay.
I must say that there's a bit of controversy over that, Mr. Agbo, in terms of which address do you then put as the venue of the meeting. And I believe that most professionals have been advised that you should use the registered address of your company.
Okay.
Which is a Nigerian address.
So thanks, Oyinda. And this is also, I'm not sure who dealt with, was it yourself that dealt with the question of unclaimed dividends, publishing lists of unclaimed dividends?
Yes, I did.
So Omoye Ajiboye asks, as regards the publishing of the list of unclaimed dividends, what happens with companies that have very long lists? Is there a way around this? Also, will this be an annual annual publication. Marinda, do you have any comments on that?
Yes, I do. The law provides that that list be published in 2 newspapers. It's going to be an annual exercise. Once the mechanism for it is that once you hold your meeting and you declare a dividend, I believe that you are given a space of 2 or 3 months about to check whether you have unclaimed dividends. Then you have to make that publication in 2 newspapers, regardless of the number of shareholders that you have on that list.
Okay, I had seen another question which I can't immediately find that questioned whether this would apply. I actually think it was a question raised by Mr. Wichia, but I may be mistaken, that asked whether this requirement would extend to the legacy list of unclaimed dividends, which, by the way, can be pretty long in some companies. Or does it only apply to dividends that are unclaimed after the act comes into effect?
Unfortunately, Cama did not make a provision for backlog of dividends that have been unclaimed. But I believe that maybe the first AGM, from when the Cama was legislated, they might be compelled to publish the list of what they had before. But until the CAC makes a regulation concerning this, it's a bit unclear.
Okay, and I think this is the perfect point at which to close this supplementary Q&A session. Close it at a point where Mrs. Ehiwere makes the point that we all know, reinforces the point that we all know, which is that there are various matters in Cama 2020 that are going to be the subject of clarification, subsequent regulations issued by the Corporate Affairs Commission. And I think that users of the statute, people who are affected by it, various constituencies, if you have frustrations, share them with your lawyers, share them with the Registrar General of the Corporate Affairs Commission, who is actually a very responsive, has been proven to be very responsible to the needs of stakeholders. Ultimately, I think that all of these, at least all or most of these challenges will be resolved over time. So on that note, thank you all. I guess we can call it a wrap. Thanks.